maybe we could slowly proceed with the first session for today. I can see all our participants present in the list, but are you there all? Are you physically at the computer? So Diana, Aleksei, Catalina, and Amna, could you maybe turn on your cameras so we can see you?
Hello.
Hello. So we have the first speaker, that's good.
Hello.
Hello. Hello, Amna. Hello, Aleksei.
Hello.
And Catalina, are you there?
Hi, hello.
Hello. So we appear to have all 4 participants for this session. Wonderful. I'll just ask you to mute your microphones when you're not speaking so we wouldn't have any noise. So we're proceeding with the 6th session in total and the first session for today, Women's Position in Civil Law. And our first speaker is Diana Matchutadze. My apologies if I mispronounced your name. With the paper Working Women and Businesswomen in French Law Codes in the 19th Century. Diana, the floor is yours. If you have a presentation, I'm about to make you the presenter so you can share it.
Thank you, first of all, for organizing this event, and thank you for everyone who is participating to this conference. As I was introduced, I am Diana Matchutadze, and I will be speaking to you from Paris about businesswomen in French law codes in the 19th century. In my draft, I elaborated on specific issues, specific legal issues, but because today we have only 10 to 15 minutes and I already used quite a few minutes to try to send my PowerPoint.
Don't worry about that. Don't count this.
I suggest we have an immersive approach and follow the life of a woman in the 19th century and examine 3 important steps of her life. So the first step of a woman is her birth, and the step is from birth to her 21st birthday. And before the French Revolution, the civil age of majority was 25. And in the first years of the Republican regime, the age of majority was lowered to 21. But in Napoleon's civil code, the age of majority was set to 21 for women and 25 for men. And in the commercial code, no provisions limit women's right to do business. If they are 21, the only condition is obviously for the woman to get the consent of her father, and she could do business as she wanted. And then when a woman reached the legal age of majority and was not married, which was quite rare at the time, she could do business without basically asking any authorization from nobody. She could do as she wanted. And I had a little scheme to show you different rights of the woman, but I don't know if we'll do without the PowerPoint, but I, for the sake of the argument and to give this presentation a more romantic aspect, we will imagine that we follow the life of Marie-Rose. And what happens to women's commercial rights when they marry? When Marie-Rose marries, she becomes almost a property of her husband, as you may have understood in the previous lecture, in the keynote given given on the rights of a female this morning. In the French Civil Code, a wife was almost a property of her husband, and it is important to understand that Napoleon had a very specific vision of the family and placed the husband in charge of everything. And we may think that revolutionaries wanted to put men and women on equal footing, but actually, after a period of uncertainty in the last decade of the 18th century, women's rights were dramatically reduced. So let's see what happens to Marie-Rose if she wants to do business. So the first question is, does Marie-Rose want to do business? If no, end of our story, she stays at home, runs a house, and enjoys a family life. But I decided that she wanted to do business. And the second question we must ask ourselves is, does she want to work with her husband? And this question is important because if she decides to work with her husband, she cannot be considered as a public merchant. Because to be a public merchant, she must do business on her own, sell her own products, and not to be linked to her husband in a commercial way. In other words, being his assistant does not give her the status of a public merchant. And just to give you some context, a public merchant is a person who buys and sells goods. And this term was invented before the French Revolution of 1789, specifically for women because they could not be a part of different corporations, such as the corporation of bakers, fishmongers, etc. And during the revolution, the cooperative system was abolished, but the expression of marchand public, public merchant, remained. So back to my point. If a woman wanted to become a public merchant, according to Article 217 of the Civil Code, her husband had to give his authorization. And this shows again how much power the Civil Code gave to a man. There was a debate about the possibility of a woman to overpass her husband's refusal to give an authorization. And after long doctrinal discussions, case law concluded that if the spouses were married under the matrimonial regime of separation of property, the judge could grant an authorization and surpass the husband's refusal because his wife's activity would not have direct consequences on his wealth. And now that I have a few minutes left, I will briefly speak about widowhood, so the third step in a woman's life, and try to end my presentation on a positive note. The life of a woman after the loss of her husband greatly depended on her social status. If a woman came from lower social classes, often the loss of a husband meant the loss of income. So it could be a time when a woman decided to become a public merchant to provide for the family. And in the 19th century, it is very interesting to see that it is a century of famous widows from the upper class. And you have great examples of firms which still exist today, such as Veuve Clicquot, who inherited her husband's champagne estate and developed it and tried to find new techniques to make even an even better champagne, or even Marguerite Boussicot, who ran her husband's company, Au Bon Marché, after he passed away, and the Bon Marché still exists now in Paris. And the last thing I would like to mention is that the Civil Code allowed men to decide to place their wives under the power of a special family council in the event of their death. So it's something that restricts women's rights. So you may find this very harsh to have a family council, but in reality, this council was very rarely established and was only useful if the couple had children or if the husband had a considerable fortune. But so yes, it was very rarely established. And to conclude, it is interesting to see how differently the civil and the commercial code treat women. Regarding the articles of the civil code, when you read these articles, you really get the sense of the patriarchy established by Napoleon, whereas the commercial code seems more liberal, and this is, I believe, this is due to the drafters of the commercial code, who were not lawyers but merchants and people who knew how a business was practiced. So thank you very much for your attention. And if you have any questions, I will be happy to answer them. I'm sorry again for this problem of PowerPoint. I really prepared a great presentation, but unfortunately, my IT skills are not the best. And thank you again.
Thank you, Diana, very much for your presentation. Don't worry, I mean, we're all getting used to this technical way of functioning. So thank you again very much. Now I would like to introduce our second presenter for today, and that's Aleksei Kapustin from Russia, from St. Petersburg, and he will present his paper, Russian Law Codes in 19th and 20th Century and Women, from gaps and inequalities to legal recognition and legal equality. Aleksei, do you maybe have a presentation?
No.
Okay, then the floor is yours, please.
Hello, dear colleagues, dear participants of this conference. Thank you for your opportunity to speak. The topic of my paper is Russian law codes in the 19th and 20th century and women, from gaps and inequalities to legal recognition and legal equality. So, the topic of my researching the relationship between Russian law codes and women is relevant due to the problem of the female legal status in the 19th and 20th century in both theoretical and practical terms. The chronological framework of the study was determined by the evolution of the legal status of women in Russia in this period. The 19th century is the period in which the legal status of women is shaped in the Russian law codes, especially due to the Russian lawmaking in the 1860s. The equality of women and men was legalized in the 20th century in the law codes of the Soviet Russia. The female legal status had a shape of its own for a long time in pre-revolution Russia. The specificity of the Russian woman's status lay not only in the actual but also the legal inequality of women and men. The actual inequality of women and men arose historically and was fixed initially in the norms of customary law and the received legal form in the laws. The legal status of Russian women had been formed under strain influences of European legislation, which were based on the provision of Roman law. Legal customs had a significant impact on the formation of the concept of the female legal status in Russia in the 19th and 20th century. Most Russian women lived in villages at the time, and their lives were guided by the rules of customary law. Usually, the legal position of a woman was characterized by several distinctive features. The right to complain to the court of the husband's behavior, several sanctions that could be applied to wives who didn't want to live together with their husbands, and the possibility of separation by mutual consent. The property rights of peasants in consent to other estates were determined not so much by kinship as by participation of the joint peasant economy. Nevertheless, it should be noted that the legislation affected the legal concessions of the peasants. The beginning of the 20th century, the peasants' views on the relationship between spouses, the position of women in a family and marriage, and women's property rights largely considered with the requirements of the law. Evolution of women's rights in the 19th century. A radical change in the evolution of women's rights in Russia occurred in the 19th century. In 1812, the first Russian women's organization, the Women's Patriotic Society, appeared. In the 1860s, a series legislative and judicial reforms were carried out in Russia. The Code of Laws of the Russian Empire was supplemented by Volume 16, which included the judicial status of 1864. Central European legislative acts such as the Civil Code of Napoleon, the General Civil Code of the Austrian Empire 1811, the Saxon Civil Code 1863, and the Civil Code of the German Empire 1896 held a particular importance in the evolution of the Russian civil status of women in the 19th and 20th century. Some scholars such Renikamp, Speransky, and etc. Have noted the significant influence of French legislation on the legal status of women in Russia in the 19th century. Russian reforms in the second half of the 19th century had an impact on the legal status of women. According to the Russian laws, 1882 and 1885, working in factories, plants, and manufacturers was prohibited for children under the age of 12. There was legislative protection of children and women in general. Night work for children and women was prohibited. Special benefits for pregnant women were established. But at the same time, the exploitation of cheap female labor remained. So did women have the right to receive a sanctuary and higher education in the 19th century? In 1863, a new university charter was adopted. It extended to 5 Russian universities: Moscow University, St. Petersburg University, Kazan University, Kiev University. According to the new university charter, women didn't get the right to enter universities, but the foundation of women's higher education was laid at the same time. A number of higher education courses for women were opened in Russia. The higher women's courses of Professor Guerrier in Moscow and the Bestuzhe's courses in St. Petersburg were the most famous ones. The problem of the secondary women's education was no less difficult. In 1860, a regulation on women's schools was adopted, which allowed for the creation of a general education institution of an open type for upcoming students. Women's schools couldn't be opened in all provincial Russian cities. Were financial opportunities, both public and private, could be found for this purpose. The finance for this purpose as always were low. The first legal literature dealing with the legal status of Russian women appeared in the second half of the 19th century. It was the result of the rise of the social movement in Russia at the time of 1850-1860. The main problems it addressed concerned the status of women in a family and marriage of women's inheritance rights, as well as certain issues of civil and criminal law. There was a critical analysis of articles of the Code of Laws of the Russian Empire in the papers the papers of Russian laws. Russian laws were comparing the articles of the Code of Laws of the Russian power with foreign language legislation. A new stage in the development of critical language literature on the legal status of women in Russia is associated with the projects of the new civil code. They included a legal provision that expanded women's rights for the first time in the history of Russian law. The idea of equalizing women's rights with the men's was actively supported in the Russian society in the 70s, 19th of the 19th century. Pokrovsky, Zagorovsky, and other researchers were interested in legalizing the equality of the sexes. They formulated the concept of so-called women's law in numerous special and general works on civil and criminal law. This problem was also started by figures of a later period like Goibarch and Pergament. Features of the legal status of women were analyzed by Yeremchenko, Kostrov, Ivanov, and others. Describing the customs that existed in various provisions of Russia, the researchers noted the features of the common legal status of women in the examined period. The fundamental work of Bachmann, Ordinary Civil Law in Russia, occupied a special place among the studies on customary law. This work contains a complete description of the civil law institution according to the present customary rules of various localities of the Russian Empire. Bachmann argued that according to customs as well as by legislation, the most important basis for the right of inheritance in kinship. Feature of the legal status of peasant woman that singled out as important is the lack of a strong connection with the family or original, which explained her removal from inheritance if there were male heirs. The preparatory works of the State Duma and the State Council in the beginning of the 20th century contain important analytical material. These documents allow us to determine the reason for the lack of equal rights for women and men in Russia law codes at this period. During the discussion on the bills on civil equality, on the woman's right to be a juror, on expanding the inheritance rights of women, and etc. The speech of Professor Petrozhitsky at the meeting of the First State Duma is of considered interest. Petrozhitsky made an attempt to justify the need to equal rights for women and men in terms of state and public benefits. The speech of Petrozhitsky contains an important methodological conclusion about the discrepancy between the concepts of legal equality and actual equality of rights with men's rights should be the first step of female emancipation. The reason for this are the stereotypes that portray women as inferior. These stereotypes have been historically cultivated for centuries in the Russian legal consequences. However, it was idealistical to pin hopes on a legislator who, according to Petrozhitsky, should have taken the first step towards the legal equality of the sexes. The idealism of Petrozhitsky's statements, in my opinion, was not justified due to the fact that the legislator cannot create law codes if these legal provisions are not in his mind. And if the legislator himself isn't a supporter of equality of sexes. The actual and legal inequality of women and men in Russia of the 19th and 20th century was determined by the state. It actively regulated this issue. The state, due to its class nature, had obviously created the conditions necessary to mention inequality between women and men. For example, in the field of labor relations, it fixed the possibility of exploiting female labor, and only under the influence of disparate workers' struggle. It slowly and reluctantly approached relations and political relations. We similarly see a certain direction in legal regulation changes which occur exclusively under the influence of labor and socialist circles and later political parties. The legal status of women entering the civil services was regulated by the Charter on Civil Service 1896, which provided for benefits in the service and titles. The expression were any rights and advantages represented by the public service. For example, advancement in the rank and awarding orders. The rights and obligations of the law allow categories of women employees were not defined by law. However, during this period, women in public service were extremely rare. They only held lower positions in some institution. At the beginning of the 20th century, the women's movement in the modern sense may be difficult to identify. However, the fact that a number of women's organizations existed, each of which focused on its rightful target according to its ideological content and the principles that were laid down. Their very existence allows us to speak of women's organization during the 1905 and 1907 revolutions as a new phenomenon in Russia, the women's movement. However, due to its novelty, the women's movement is difficult to evaluate as noticeable forces in this period. Numerous women's organizations acted in the revolutionary conditions of 1995 and 1997. They played a special role in the evolution of general equality. The Russian Women's Mutual Charitable Society, Union of Women's Equality, Women's Progressive Party, and the League of Women Voters sent a joint delegation to the Commission of the Duma. They considered applies and considered applies. The women organization published and distributed speeches of debates supporting the empowerment of women. A legal commission was created in 1906 under the Russian Women's Mutual Capital Society, providing experts of the legislation. This commission identified articles that restricted women's rights. The result was emergence of bills on women's equality. The bill aimed to change and aid novelty to the laws. It was discussed at the meetings of the First State Duma in the framework of the civil equality problem. The bill on women's equality consisted of two parts. The first part contained a law of general constitutional nature, abolished the restriction domestic legislation for women without a detailed and article by article list of them. In the second part, the list of articles of the current law subject to cancellation, addition, and change was given, located in the volumes of the Code of Laws of the Russian Empire. In 1912, the State Duma discussed and approved a bill on the extension of women's inheritance rights. On 1912, the Russian Emperor signed the law on the rights of inheritance by law, the will of women, and the law of estates. They equalized women with men only in sections of movable property. When it came in inheriting land property, the share of the sister compared with the brothers made 1/7. The government didn't view the problem of gender inequality as a matter of primary importance. This conclusion can be drawn from the parliament preparatory work. Most of the Duma deputies didn't consider it necessary to solve the problem of the female status immediately. Despite the progressive position of some Duma fraction and deputies, the legislators were not willing to solve the problem of legal regulation of the female status in gender inequality. Legislators were failing in their attempts to draft comprehensive laws protecting women's rights for 11 years. It is for convocations of the State Duma. They didn't solve problems such as getting women equal political and civil rights as men, improving working conditions for women, and providing legal protection of motherhood and childhood. Russian legislature regulated the electoral process. Provides for the passive participation of qualified women in the conduct of elections. Until 1907, they were only allowed to transfer their votes by proxy to male relatives. The 1970 revolution had a great influence on the evolution of women's rights. For several months, women were given the right to vote in the formation of local self-government bodies, and accordance with the new laws on elections to Zemstvos and city dumas of 1970s. In the resolutions of the provisional government of the 12 July 1917 on the approval of section I, the first of the regulations on elections to the Constituent Assembly. It was stated that the right to participate in the elections for the Constituent Assembly is enjoyed by Russian citizens of both sexes, who will be 20 years old by the election day, regulated of the approach qualification. The Bolshevism of the Soviet made it possible in September 1907 to approve the third last section of the regulations on elections to the Constituent Assembly. According to this act, women were granted the same active and passive suffrage as men. Women's participation in the elections of characterized by the awakening to an active social and political life. It both an important social cultural shift in Russia's society. Nevertheless, women candidates were very rare in the electoral list. This situation indicated that the traditional Russian stereotypes which oriented women towards the family were still strong in the public construction along with the public distrust in the ability of a woman to fully solve public policy issues. After the victory in the October Revolution of 1970, the Bolsheviks were able to consistently pursue a policy to wake up the social activity of women to intensify the struggle for equal participation in public life, both in Russian society and in even more traditional communities in Central Asia. The Caucasus and other regions. Further on the issue of the legal status of women was discussed in the context of civil war in Russia, and then in the extraordinary conditions of the Great Patriotic War. At the time, women actually took on male responsibilities as well as their own. As a result, women clearly demonstrated gender equality. At the same time, gender equality was encouraged by the Communist Party. In Soviet Russia, women got a real opportunity to pursue their goals and interests on an equal basis with men in such spheres as educational, science, medicine, and etc. However, in the political sphere, in the sphere of government and industry, the percentage of women remained small. So, in rural councils and councils of people's deputies in 1934, there were 27% and 31% of women deputies, respectively, in 1937 in the Supreme Soviet of the USSR. There were 16% of women deputies. Only by the 1970s, 1918s, did the number of women in government bodies become equal to the number of men. The Russian laws of the 1960s saw the overcoming of gaps in legal regulation of the position of women. The rights of women with children, pregnant women, and women in childbirth have been greatly expanded. The 93 Constitution also proclaims gender equality. However, unlike the 1977 Constitution, it only declares equality, while in real life, due to the lack of guarantees that should be provided by the state, women became one of the most vulnerable groups. Open the explanation of various kinds, including labor, sexual, and etc. The Russian legal system traditionally includes two legal spheres: public law and private law. An analysis of civil private law of the 19th century allows determining the legal status of a married woman, as well as the hereditary rights of a woman as subjects of law. It is important to note that from 1930s to 1990s, there was no private law spheres in Russia, since private property didn't exist in the Soviet Union. During this period, individual property existed only the form of personal consumer property. This affected the civil status of women, especially in matters of inheritance and property rights of married women. For the first time, the institution of private property was established by the law of property in the EurAsEC in 1990. In conclusion, I would like to say that in the 19th and early 20th century, the legal status of Russian women was characterized by weak social and legal protection, lack of political rights, inability to pursue and use their professional knowledge. In general, legal support of the rights not only women but all of Russian citizens was not effective in the 19th and 20th century. These problems influenced the creation of the first domestic laws and distinguish women as individual subjects of law and provide for the gradual expansion of their legal capacity. The main reason for the lack of gender equality in the 19th and early 20th century in Russia was the legislature in whose legal consciousness there was no evidence of the need for full emancipation of a woman. It is not enough to fix the equality of sexes in the law until it has taken hold in the legal understanding of not only society but also the legislature. Further, only after the February and October Revolution of 1970, the result of which was the coming to power of the Bolsheviks did the legal status of women began to improve. Gaps in legislation were overcome as the legislator not only established gender equality but also established guarantees to mention this equality, including position discrimination. The Bolsheviks also eradicated their old views on the social, economic, and political status of a woman in society. The evolution of women's rights in Russia in the 19th and 20th century was a process of overcoming in a legal codex of overcoming gaps in a legal codex and ensuring legal equality. Thank you for your attention.
Thank you very much, Aleksei, for your presentation. It was very interesting. And now we move on to our third presenter for today, and that's Karolina Fabara from Shangai University of Finance and Economy. She will present her paper on the topic of the effect of gender equality on economic development in China. Karolina, one more time, our sincerest apologies that you had to present in the middle of the night. We thought you were going to present from Shanghai and not from Panama, so we took into consideration the wrong time zone. Again, one more time, sorry about that.
Hello with everyone, no worries. I am so happy to be here with you, and I am so happy to know that are many people writing papers and with the same passion as me. I want now to share my screen.
Let's see if it works. Okay. It's loading. Okay. Okay, so try just changing the slides so we can see if you have the control. Great.
It's
You
okay?
can start now. It's okay. We see it. Yeah.
Great. I don't know if okay. My paper, the name is The Effect of Gender Equality on Economic Development in China. My name is Karolina Fabara. I am from Ecuador, and I am studying my LLM in Shanghai University of Finance and Economics. I cannot move. Okay. Okay. The outline of my paper have five basic parts, which are introduction, how society affects law, how law shapes society, entrepreneurs, and the conclusion. In the introduction, the contribution of women is fundamental for the progress of the economy. Entrepreneurship is one of the forms of economic empowerment for women because it helps to generate gender equality, development, and employment. The purpose of the paper is to analyze the gender equality and empowerment of women in China through history and laws, to observe how law shapes society and how society affects law. Okay, gender equality is a basic national policy in China. The interest in female entrepreneurship has increased because females have been assigned a special role in the society. In China, we have the labor law, the employment promotion law, and the human rights law. Each of these laws stipulate that women's equal employment rights shall be protected and gender discrimination in employment is prohibited. So, so the business environment for women reflects the complex interplay of different factors such as social, cultural, religious, economic, and educational factors. It's important to understand Confucius' philosophy and how it influenced the role of gender equality in the economy. Okay. So, how society affects law? The traditional Chinese law was more a moral code because Confucian values ideologies preferred the rule by morality rather than the rule of law. For Confucianism, women must follow the rule of the threefold obedience, which means they must be obedient to their father in childhood, to their husband during marriage, and to their son in old age. So one classic Confucian proverb states, "It is a virtue if a woman has no ability," meaning that a woman's duty was simply to care for her husband and raise her children. The Confucian idea that women are subordinated to men, here we can see. So Confucius believed that childbearing was a woman's more important role in the society. However, Chinese women have suffered discrimination through thousands of years. After the founding of People's Republic of China in 1949, the socialist system and laws facilitated a high level of women's participation in both political and economic life. In this way, the Chinese government eliminated discrimination against women and improved in different aspects of gender equality. For instance, access to education was one of the implementations. Thus, the 9-year-long compulsory education requirement in China was enforced. So this was very important. So since 1949, the state was issued regulation and laws to provide protection in the workplace for women by ensuring equal opportunities, including PRC Women's Rights Protection Law, the PRC Labor Law, and the Women's Work Protection Regulations. The government started to reform some laws that try to discriminate against women, such as the marriage law, because they permit polygamy and also bride prices. Additionally, women were also encouraged to pursue careers that traditionally reserved for men, such as drivers, tractor drivers. Okay, women become more highly educated and trained, even though a woman's status is affected by Confucius values in the corporate world. In China, Confucianism is heavily ingrained in society. In Asian countries, the effort of women fighting against gender discrimination is weak. This may in part be due to women being less sensitive to discriminatory behavior, perceiving them as a norm under Confucian values. Chinese women are more likely to respond passively to gender discrimination due to their cultural heritage. Even after all these changes made towards an equal opportunity society, it is necessary that laws be enforced, which means to continue working on them, because we don't have the equal right until now. So it's important to continue working. How laws shape society. Laws have changed, and the achievement of gender equality is the basic national policy in China. In the Constitution of People's Republic of China, it is stipulated that women in the People's Republic of China enjoy equal rights with men and all aspects of life, including political, economic, cultural, social, and family life. The labor law of the People's Republic of China specifies women shall not be subject to discrimination due to their ethnic background, race, gender, religion, beliefs, and women shall enjoy equal employment rights with men. Also, the National Human Rights Action Plan of China is an important measure taken by the Chinese government to ensure the implementation of the constitutional principle of respecting and safeguarding human rights. Some provinces also encourage the participation of women, such as Guangdong province, that promulgate measures for the implementation of the law of People's Republic of China on the protection of human rights. The Standing Committee of People's Congress in Shenzhen also promote gender equality, and this is the first local administrative regulation advocating gender equality in China. Law of People's Republic of China on the protection of human rights and interests of women was promulgated on 2018. This law is formulated to protect the legitimate rights and interests of women to promote the equality between men and women. So we can see for the time of this law that they are continue working on gender equality. So laws are important element in the inclusion of women in the country's economy. Also, the economic participation through entrepreneurs plays an important role. That's why I include entrepreneurs in the paper. So in the past, Chinese women were not so active because they were in charge of primarily of household chores. The lack of access to formal credit made it hard for women to run her own business, and traditions, customs, and cultural sometimes has also a negative influence. So a series of entrepreneur policies specific to motivate female entrepreneurs activities have been formulated and carried out by the Chinese government. These policies include subsidies for professional training, small loan guarantees, and also preferential tax treatment, providing beneficial conditions for these women entrepreneurs. So, for example, in the province of Jiangsu, banks will give a priority to support women entrepreneurs via a simplified process. So, in general, interest in female entrepreneurs in developing countries has significantly increased. The reason can be different, but one can be due to the role of entrepreneurship in the economic development process. The increasing number of female-owned enterprises is partly due to the increase in women's educational level and the economic pressure that women face in their household. Supporting and expanding female entrepreneurship is important not only for empowering women, but also to reduce poverty in developing countries. Women entrepreneurs create new jobs and competition between business, which help to boost the economy. As a conclusion, I want to say that through the paper, we can see that Confucius values support male superiority, male domination, and female subordination and have a great influence in Chinese society. Understand the history of a country is an important step to understand the promulgation of laws, and this case in female entrepreneurship. Despite the progress that women have made in the economy, it is necessary to continue working on the promotion of gender equality. So through the paper that I have wrote, I also encourage you to read my paper. I will be so happy to answer any question that you have further. But in this paper has been discussed the importance to understand how the culture and beliefs of a certain place affect the creation of laws. And also it reflects how law work to have a better society, in this case, seeking of gender equality. That's what my contribution for law, codes, and women. Thank you so much for your attention.
Thank you very much, Carolina. This was a very good presentation. And now for our final speaker of today, Amna Hassan, who is a PhD student at the University of Pecs Faculty of Law, and her subject is Women and Contracts in Pakistan, a comparative analysis of women's rights on the basis of Anglo-Saxon and Muslim legal traditions. Amna, I am about to pass the presenter rights to you so you can share your presentation. You should be able to use your PowerPoint now.
Hello, can you hear me?
We can hear you right now. Yes, I can see you too now.
Okay. Hello, everyone. My name is Amna Hassan, and let me upload my file, but I cannot see the option for sharing.
You can't?
Yep.
It should be at the
That's like-
bottom of the screen.
No, there
Stop
is.
video and then share.
No, there is the option to share, but I do not have the access for it. That's like, I sent you by email. If you could
Yes, I got it, but could you try again? Maybe you tried while I still didn't transfer the presenter, right? So if you click share and then share file, what happens?
Let me share you through email.
No, I got the email. I have the file, but just you try once again through WebEx, because maybe you tried while I still didn't make you the presenter. So maybe you can do it now.
But the fact is, I cannot see the option. The option here is locked for me for sharing.
Okay, then I'll just share it from my side. Just a moment. Then you'll just have to, I'm afraid you'll have to tell me when to turn the slides.
Because I don't see the option to share, otherwise I could have done that.
I understand,
Or
but
maybe here? No, it's not here.
no, you can't see it, right? Or
Yeah.
can you? Can
No,
other people, could someone just confirm, can you see the presentation?
Yes, we can see it.
Okay,
Yes.
so please
Okay, so
go on and just tell next slide when you want me to turn it.
Okay, sure. So the topic is women in Pakistan. So I'd like to do a comparative analysis of rights of women in Pakistan based on the two models of law which are being practiced in Pakistan. One is the Sharia law, the other is common law since we got independence. So let's move on. Before we move on, I would like to give a quick overview about my paper because this is kind of part of my thesis for PhD, and this is a sub-chapter in the thesis, and it covers some topics which I would like before going into detail. So the first one is a concept and historical background of Sharia law in general, and then the historical background of status of women in Pakistan. And then we'll see what is the status of women in Pakistan based on the parameters that is under Sharia law and under common law. And then we'll conclude it with a comprehensive analysis. So the next slide will be about the introduction. Nina, could you like? Yes. So it's proposed that Pakistan, as I told you, we use a mixed legal system. It is a combination of Sharia law and common law. So when Pakistan got independence in 1947, the English laws remained in force until a new constitution could be chalked out. So the founder of Pakistan, also known as the father of the nation, Muhammad Ali Jinnah, envisaged a legal system which could be a compromise between the common law and the teachings of Islam. But this compromise could not be reached during his tenure, but his vision was long taken on ahead. So what actually is Sharia law? It is actually a fundamental religious law that forms the core Islamic tradition. And according to the long-standing theory of Islamic jurisprudence, in Sharia, four fundamental sources is which comprise of the Holy Quran, Sunnah, which actually are the acts and sayings of the Prophet, and then the Ijma, which is juristic consensus, and Qiyas, analogical reasoning. So, if we see in Islam, there are several schools of thoughts who have been developed based on these four fundamental sources of Sharia law, and they operate as Hanfi, Maliki, Shafi, Hanbali, and Jafris, which are also known as Shiites. So the next slide. If we see, traditionally Sharia law was construed and comprehended by the independent muftis based on the Islamic teachings and legal sources. And after that, the fiqh, which is actually the understanding and practice of law, that was expounded by the religious scholars, mostly by way of legal opinions known as fatwas. And historically, this fiqh was enforced in Sharia courts by a judge, and the judge was usually appointed by the ruler of the time, and it was the duty of the judge to settle issues related to civil law, disputes and social matters, but the criminal matters would actually go over to the sultanic courts, police, market inspectors, who had the jurisdiction to deal with such matters. However, the minority communities, they enjoyed legal independence in matters pertaining to personal status. That is, they were no longer subdued, or they were no longer subjugated to the Sharia law. So this was kind of a relief. Now, what we see is that Sunni jurists took centuries to acquire a credible position in the bureaucracy, and the first sign of their struggle could be seen in Ottoman Civil Code, where they actually sought to codify the Sharia law together with the state law. Next slide, please. But if we see the scenario in current times, that is that several statutes based on European models are in regulation in most of the Muslim countries, including my own country, Pakistan, which is actually an attempt to replace the classical Sharia law, or maybe to synchronize the common law or the English laws with the Islamic laws. Now, not only this, the Muslim countries also brought their legal education and their judicial practice in accordance with the European practice. And although there are many Muslim countries who still hold on to the notion of their Sharia law in their constitution, yet you can say that classical notions of Sharia law specifically remain into the areas of family laws or personal status law. The legislative bodies in these Muslim countries aimed at codifying the rules of Sharia law in an attempt to modernize them with the changing needs of the hour without abandoning their basis in traditional jurisprudence. So if we see in the 20th century, there were several Islamist movements which moved or transformed the modernized attempt into more Islamization attempt, like they wanted Sharia law to be implemented and enforced together with the hudud punishments like stoning to death or cutting of hands if you are a thief. So these hudud punishments were like held in esteem by those Islamic movements, but we see that these hudud punishments are held with symbolic importance in seeking international attention. The Muslim countries are in actual really reluctant in enforcing such punishments, hence like hanging till hanging that is banned in Pakistan, or that has been not banned, that has been suspended in Pakistan due to the international pressure, but that does form the part of hudud punishments. So next slide. Now we see what is the status of women in Pakistan. Well, to be honest, it is a position of or a status of gender subordination that is based on their class and region. And the simple reason is the fact that uneven development in the socio-economic sectors and impact of tribal and feudal systems on their lives lead to such gender subordination. Now, there were several religious groups and ulamas who acquired power during and after the period of Ziaul Haq, who was the ruler in Pakistan in the timings of 1979. And they actually, those religious groups and Ziaul Haq himself, they supported women's subordination in Pakistan, and they even did not allow them to use DNA evidence in their rape cases. But with the passage of time, like in recent times, this has been changed. Next slide, please. Now, the women are really allowed to prove their case through DNA, and the judiciary has been up to it, accepting to it, and has made modification. And moreover, there are certain examples in Pakistan where some women do hold esteemed position. And one of the most celebrated position is by a twice elected Prime Minister, Benazir Bhutto. And although there are some examples of improvement and modernization, but still we lag behind in the case of majority. And there is widespread domestic violence, increased child marriages and rapes. They are a bitter truth of the Pakistani society. So, next slide, please. We will look briefly into the historical background because I don't think we have much time. So historically, if we see Muslim reformers like Sayyid Ahmad Khan, they advocated for women's right to education, prohibition of polygamy, and women employment by way of education. Jinnah, the founding father of Pakistan, also was known for positive outlook towards women's right, and his sister was well-known feminist struggling figure to elevate socio-economic discrimination against women. If we see, Jinnah also reflected that women were actually constructive in Pakistani movement towards the Pakistani independence movement in 1940s, and they did play a pretty crucial role. So when Pakistan came into being in 1947, at that time the women were given the right to vote, and this right to vote is granted to women in Pakistan since then onward, and there is always a seat reservation in parliament for women to give them opportunity to participate in political process of the country in every constitution since 1947. Next slide, please. But if we see the current constitution that is going, that was of 1973, which was given by the People's Party, a government, and they enacted that constitution, and in that the constitution adopted the policy of gender equality, in particular stating that there shall be no discrimination on the basis of sex alone, and it also provided additional protection in matters of marriage, family, mother and child, along with a guarantee of full participation of women in all spheres of national life. So if we see the tenure of 1970 to 77 was considered to be a period of liberal approach towards women and rights. The women's got their rights acknowledged, and they had a better approach and advancement towards what they wanted to achieve. But next slide, please. If we see the tenure of 1977, where Army General Ziaul Haq, who overthrew the elected government of People's Party, he took charge, and in his tenure, the status of women is greatly contradictory. If we see on the brighter side first, we see that the regime took several steps to advance the women's rights by establishing a women's division, a commission on status of women, and the aim was basically to adopt an integrated approach to improve women's status. But if we see the darker side, which is actually the bitter truth and the most effective part since or impacting part since to date, is the introduction of Hudud Ordinance and Qanun-e-Shahadat Ordinance, which is known as Law of Evidence. In that, he prohibited women participation in sports and promulgated Parda, and he also suspended fundamental rights in entirely provided expressly in the 1973 constitution. So it was like under these Islamization process of introducing these laws and ordinances that he subjugated and subordinated women into the other sex, and that actually did much worse to the society of Pakistan. So next slide, please. But if you see, after his tenure, there was a reaction amongst the feminists, and there was a feminist struggle that arose in 1980s, and that became the first wave, and it got its first appeal in the, this feminist movement gained most of attraction and in the timing of female Prime Minister Benazir Bhutto, who came after her, and she served twice, and her tenure was also great for women as she concentrated on NGOs and providing rights for women and improving their situation. But due to the turmoil in Afghanistan in 2000, the Taliban took over refuge in the KPK region of Pakistan, and they implemented strict Sharia codes in the region, thereby again impacting worsenly on the women in Pakistan. So we can see the example of Malala Yousafzai, as everybody would be known, that she was in that area, and she stood up for the educational rights of women. But what happened? She got shot, and how she survived, then everybody knows. But the fact is, there are few women who had the courage to stand up to the situation only, but the majority is subdued and subordinated. So next slide, please. And if we see that the dismal in this Islamization process, in this liberal status of women, was the tenure of Prime Minister Nawaz Sharif, who took over the office, and he was also like Ziaul Haq, who implemented Islamization process. But again, due to the after his tenure, there was again PPP, who really raised women esteem by giving them esteemed positions like Speaker of Parliament, then Foreign Minister or Advisory Minister, and also passing of bills like Protection Against Harassment of Women at Workplace Bill and many other bills. So if we see that the situation in mostly the situation in People's Party tenure was liberal approach towards women, but in other tenures it was usually conservative and approaching towards Islamization. And if we see the current government going on, that's for Pakistan Tehreek-e-Insaf (PTI), that is also pro-Islamic, and we see that it won't do any good towards the status of women because it is pro-Islamic. So next slide, please. Now we shall see about the rights of women under Sharia law. So first is marriage. That marriage is considered to be a contract, and it is true that Islam provides women with rights related to marital issues. Yet there are certain cultural practices which incur heavy impact upon offer and acceptance procedure past Islamic prerequisites. The historians allege that women in pre-Islamic era enjoyed no legal protection, having no rights, and men were allowed to marry as many women as they wanted, but same was refuted to the female. Next slide, please. Now, according to the teachings of Islamic reform, marriage is comprised of three main considerate aspects. One is the legal aspect, which says that it is a contract in three senses, that it requires an offer and acceptance from both the parties, contains a provision for breach, and allows for revision or modification of provisions acceptable to both parties. And a social aspect, that it is considered as a contract, and religious aspect, that it is a sacred covenant. Now, anyways, in Islam, if we understand that what marriage is, we see that what are the rights of the wife. So wife has a right as an heir, and a widow is entitled to dower after demise of her husband, and she also has the right to retain the property of her deceased husband only at such times when she becomes capable of collecting her dower or meher. But as the majority opinion of Islamic scholars favors the concept of meher being non-inheritable, so a wife's right to the property of her husband remains questionable and controversial to date. The next slide, please. So apart from the Islamic tradition, men are also allowed to marry for women, but same is refused to the women, and this is actually controversial. And then, and in case she marries a second woman, yeah, she is believed to have committed bigamy, and her children from the second marriage are deemed illegitimate. Now, although Islamic teaching speaks of equality between the sexes, there are double standards for that. For instance, we can see that men are allowed to marry a woman of other faith, like a Christian or Jewish woman, but the same is not acceptable for women. And if Muslim women did dare to do so, she's outcast, and she's like her marriage is invalid or void. Next slide, please. And moreover, there are some other kinds of marriages in Islam which also render some cruel practices and discrimination towards women. Like the one is nikah halala, which is referred to as tahleel marriage, and the other one is mota marriage, which is contract marriage. Mota marriage is a contract marriage, which is like a simple contract between two parties, and that is for a stipulated time. And when the time is elapsed, the marriage elapses too. But in the tahleel marriage, it is the thing that if a husband wants to remarry her divorced wife, for that purpose, her wife has to first marry some other Muslim man, get that marriage consummated, and seek divorce from him in order to remarry her former husband. So this is actually a cruel stipulation which needs to be abandoned, and I think that it is no more practiced in modern times. Next slide, please. The Shiite sect of the Muslims, they support contract marriages, and they put their stress on the Islamic teachings from the Surah An-Nas, verse 24 of the Holy Quran. And but the Sunnis, the Sunni sect, they don't agree to that. The next slide, please. Now we see what about divorce. Now, although divorce carries no immoral connotation, it is strongly discouraged in Islam as it demolishes all the existing family setup. So the abhorrence towards divorce is expressed numerously in the Holy Quran and by the Holy Prophet himself. Now, despite that, divorce could be done in three ways. Firstly, when either of the parties dies, or the other form is by the act of the parties, like when they decide mutually, they can do that. All right. So when they decide, they can like break off the marriage contract, and through the judicial procedure, that is by seeking the court, and there they get a decision. Now, next slide. After divorce, we have yeah. Next, please. I just warmed it up. Next, please. Yeah, custodial rights. Well, if you see custodial rights, even under custody rights, the woman fares really worse than a man. Like if he gets a divorce, she doesn't have the right to keep her babies, her children. She will have to give the custody to her husband, and even if he remarries some other women, the custody won't be given to the mother. Now, even the mother is a natural here custodian for the kids, but she won't be given that right. And if she marries some other guy, she would even be denied the rights to see her children. So that's the case that in custody rights, the women also fares really far worse. And then we can go on to the employment rights, please. The next slides. So under Sharia law, women are provided with the right to work, but it is subject to a number of factors and strict circumstances. Like she can work. It is really restricted. Muslim countries do not provide women an equal share in job prospects as opposed to men, and due to the fact that women are by and large prohibited from participating in public life, as men can do that. So she is usually required to stay at home while the man provides. And although she has rights to do employment, but she is strictly prohibited by whaling and other factors. And the next slide, please. Property rights and inheritance. Even in property and inheritance rights, she is granted to she is allowed to do to acquire property and to own that property, and she can inherit from her father and her parents. But even then, she fares really less as compared to men. And if we compare a share of a female to a man, that is one half of a man. Like if it is one portion for the son, then it is half for one daughter. So that's it. She doesn't have the equality which is proposed and postulated by the Islamic teachings. Next, please. Next. Yeah, we're going to answer. In testimony also, the testimony of a woman is also half to that of a male. And again, testimony for women in especially in the matters of financial matters, she is. Can I get to the other slide, please? Yeah. So the women, except for certain matters of bodily affairs like divorce, marriage, freedom of slave, or giving the birth to the children, in these matters she has a valid testimonial rights. But in other matters, especially the financial and criminal ones, she is still not granted the equality, and she is treated with the controversy. Next one, please. Now we see under Anglo-Saxon common law, there are we see that despite stringent and unfavorable Sharia laws, women still have some necessary legal safeguards to be provided to them under common law in Pakistan. And although several religious scholars and extremists consider that bifurcation, sorry, a moment, please. Yeah, I think I need to go to the other slide. Yeah, so women are provided legal safeguards apart from the stringent and unfavorable conditions provided in the Sharia law, and that is through the common law practice in Pakistan, through the constitution itself, and they have the legal right, which is described as a right created or recognized by law, and they have rights provided under constitutional law 1, and under criminal law 2, under civil law 3, and under family law 4. So we can move on. So rights to them under constitutional laws are right to life and liberty, equality, freedom or right to education, right to property, right to culture, right to constitutional remedies to protect fundamental rights. And then there are rights under criminal law, which are guarded by Pakistan Penal Code, Criminal Procedure Code, offences of qazaf, enforcement of Had Ordinance, and rights of women prisoners. Then we have rights under civil law. Next slide, please. And these are provided by Code of Civil Procedure, Factories Act, Married Women Property Act, Mines Maternity Benefit, and so on. Then we have under family. Next slide, please. Under family law, Then there are dissolution of marriage, Muslim Marriage Act, Muslim Family Laws Ordinance, West Pakistan Family Courts Ordinance. So these are all the statutes under which women are provided rights in the specific categories. So now we move on to the conclusion. Conclusion. I don't think we have much time for case study analysis. So the conclusion is that women's rights are human rights, and they can be secured only if Pakistani society is free from gender-based violence and addresses women's position by viewing women not as only mothers, daughters, sisters, wives, but also human beings. So in light of these facts which I have stated above or have written in my paper, status of women in Pakistan, there needs to be improved legislation, and for that Supreme Court of Pakistan has been doing much of the struggle and work, and we see that how this progressive attitude of the courts towards the status and rights of women, there is still much work to be done, and there is a dire need to find a common core between the rulings and laws of both the legal systems in order to find solutions to the existing laws of inequality and subordination of women in Pakistan. So thank you so much, and that's all.
Thank you very much, Amna. I'm sorry for having to cut you short, but it seems that everyone was speaking for a little longer and we're running a little behind our schedule. I don't know what the technical reason is that some people were able to share their presentations and some weren't. And sorry to Diana, your presentation actually arrived only after you had already finished your speech, but now I'm going to share, at least during the discussion, I'm going to share your presentation so people can see it, because you made a really pretty presentation. So I'm opening the floor to questions, and I'll just slowly scroll Diana's presentation during that time so you can see it. If anyone has any questions, do speak up.
So if no one is asking a question, I would just like to thank all of the present presenters one more time for their lovely presentations. And there have been some presentations about legal systems that we don't hear about that often. So at least for me, it was a learning experience listening to some of you. I'd like to have just one quick question for Carolina. Hi. This was actually the first time that I've heard any kind of presentation about the Chinese legal system, so it was very interesting for me. I have just one question, if, of course, you have the answer. So we heard that there have been a lot of attempts by Chinese lawmakers to create laws to reform the legal system and give women more opportunities and create an equal opportunity for them as well. But do you maybe know, is there any change in the mentality of the society? Like, are the Chinese people more accepting of the idea that women are equal with men? Because, as you said, Chinese society is very traditional and very patriarchal, based on old values and religion, etc. And we know that although laws can be progressive, if they're not accepted by the society, their effect is very little. So is the mentality of Chinese people changing? Do they see women as someone who's equal to men and someone who is not solely confined within the family and can, you know, be functional part of society?
Yeah, actually, that's why I say the women are like fighting passively, because Confucian values, the cultural heritage is really like strict in because of the Confucius values in China. Even though there are many laws that have changed, like for example, giving more rights and empowerment for women, nowadays are many women in business, and also many Chinese girls are going abroad or even studying in China. They are doing a lot of hard work. And also in Beijing, they have a university that the name is University of Women. So I think even though they have this cultural heritage of Confucius values, they is a lot of work in China about gender equality. And nowadays they have changed the law of marriage law, they create these women rights and the labor law. So, I mean, there's still a lot of work to do, but they have some changes. And women in, for example, at universities or at enterprises, you see a lot of Chinese women working and they are both CEOs. So I think laws have made a good part there in China.
Thank you
And
very
I'm
much.
happy, thank you so much for hearing. And I think this thing of Chinese women in like gender equality in China, I think is really nice, because even though it's a many history years of like cultural heritage, they are still working on it. So I think that is valuable.
Thank you very much. Thank you.
Thank you.
So are there maybe any more questions? If someone has a problem with sound, you can type it out in the chat. Okay. I guess no more questions then I presume. Let me just see the time. So it's 1 and 10 minutes. Let's then have just a 10-minute break so that we don't start too late with the next session. So it's now 1 and 10, so we can start at 1:20 again. One more time, I thank to all of the presenters, and we'll be back in 10 minutes.